Welcome to Vishnu's Legal Corner. In this video, we are going to say about Section 9 of the Code of Civil Procedure 1908. So basically, the bare language of the Section 9 says about the court shall, subject to provisions herein contained, have jurisdiction to try all the suits of civil nature, excepting suits of which the cognizance is expressly or impliedly barred. So what the Section 9 try to say is, basically the courts have the power to try all the suits which relating to the civil nature, but it bars if any other law or any provision contained in the CPC, if it is barred, then the court doesn't have the component to take up that case. So in Section 9 there should be two essential conditions. First is civil nature. So the word civil nature is not defined in the code, but however it relates to the private right and remedies of a person. So hence a suit is deemed to be a civil nature if its main focus is the determination and enforcement of a civil right. For example, suits relating to right to property, suits for the specific relief, suits for dissolution of partnership, suit for recovery of money, suit for damages for the civil wrongs. These are the examples which relating to the civil nature. Next comes express or implied bar. This can be like the bar or the jurisdiction can be expressed or implied by the specific provisions of CPC or any other laws. For example, if you take up the Income Tax Act, Sales Tax Act, the specific bar is mentioned in the act itself, so the civil code does not have the jurisdiction on those suits, like if they can't file the case relating to those kind of things. Next comes implied bar. You can take the example of recovery of costs incurred in the criminal prosecution. For example, in the criminal prosecution, there was the recovery of costs incurred. A civil court does not have the jurisdiction to entertain those cases, and also enforcement of a contract against public policy, which we learnt in the Contract Act itself. For those kind of things, the implied bar has been imposed as per the Section 9. So there are two important case laws in relating to Section 9. One is CT Nikam vs Municipal Corporation of Ahmedabad, where the court held that appropriate forum for the resolution of industrial dispute is the forum constituted under the Industrial Dispute Act 1947. Jurisdiction of the civil nature is impliedly barred in such cases. Another case is Dalubai vs State of Madhya Pradesh 1968. The Supreme Court laid down the principle to determine the exclusion of jurisdiction. If the statute creates a special remedy, civil court's jurisdiction is barred. But there are two exceptions to in these things. One is the statute does not provide an adequate remedy. The tribunal acts beyond its jurisdiction. In those two circumstances, there is no bar on such circumstances. So these are the things which have been covered under Section 9. So in a nutshell, if I have to summarize the Section 9, it says the courts to try all civil suits unless barred. So basically the civil courts have the power to try the suits which relating to the suits of civil nature, but it should not be barred under any specific provision or implied bar. For express bar, you can take up the concept of res judicata Section 11 also. Thank you.